Hey, I'm Paul Rabalais, and in this video we're going to talk about how owning the usufruct of land or real estate that's not your home may result in you not qualifying for long-term care Medicaid if you go into a nursing home. Okay, so that's a mouthful. Before I get into it, let me go over, there are some videos in this channel that I make that apply to everybody. They apply to you whether you're young, old, live in Louisiana where I am, or in another state, or quite frankly in another country. And then there are some videos that apply to a much smaller group of people, but when they apply, they're really important. This is one of those videos that really applies to people who live in Louisiana who may own what's called the usufruct of property. All right, and I got to chuckle. It seems like the channel's getting more and more views every day, every week, and more comments as a result of more views. And I thought it was funny, a couple of days ago, Gilda wrote in a comment, I made a video about whether you should leave money to your grandchildren, and in her comment she wrote, I've been binging on your videos all morning, very good information. So that just made me chuckle. Never thought anybody would binge watch my videos, but hey, if you find it entertaining or educational or whatever it is, go for it. Gilda, thanks for binge watching the videos. Okay. Many people, especially the middle class, when it comes to nursing homes and Medicaid eligibility, the wealthy, they can cover that expense themselves. The people who are flat broke, they're going to get the government help because they are flat broke. It's the middle class that kind of get whacked. So many in the middle class worry that if they go into a nursing home and if they own land or if they own other assets, they're going to have to consume all of those assets, spend them, sell them, then spend them, before they get any assistance for their nursing home care. And it's a valid concern because somebody turning 65 years old today has a 70% chance of needing long-term care in the future, and that care is expensive. Depending upon where you live, the facility, you could say fairly conservatively that long-term care costs are about $7,000 a month. And if you have a married couple and they're both in there, double that, $14,000 a month. Boy, over 3 or 4 years, 5 years, you could wipe out $1 million. Okay, so the rules are you have to consume all of your assets before Medicaid, that federal program that's administered by the states, before Medicaid covers that long-term care expense, that long-term skilled care if you're in a nursing home. Some people, in addition to owning their home, and oh, by the way, I'm gonna link a video up there on how to protect your home if you enter a nursing home. Just check up there. But this one, I want to refer to some special rules that apply when people, in addition to their home, they own other land or real estate. Some of the parishes in Louisiana are very rural, and it is very common for people to own, some fairly large tracts of land. Some people inherit property and they own their own tract or their own property, or they own property with siblings because they inherited it from the parents. Some people all over the state own, a piece or two or more of rental property because they did that as an investment and they wanted to, own more property. So I know that because some lawyers in Louisiana have told me, they come to me and they say something like, Paul, I don't do a whole lot of this Medicaid stuff, but some people came to me owning some land and they wanted to get it out of their name for nursing home purposes. So Paul, what I did for them was I did an act of donation. They donated the property to their kids, but they reserved the usufruct. And, we're all thinking that that's, getting it out of their name for nursing home purposes. So if that parent or parents go into the nursing home in the future, they're going to be good because they, did that act of donation. Well, I got to tell you, that thought process is flawed. And so, and I'm going to tell you why. And whenever I have to explain something like this, I always like to go to the rules. So I did go to the rules, and I pulled out our Louisiana Medicaid Eligibility Manual, the provisions that apply to the valuation of usufruct. And I'm just going to read you the important points, but here's what it says regarding the valuation of usufruct. It says, if there is usufruct over items such as land, houses, and it goes on to mention other things. Then it says, determine the value of usufruct held by the applicant/enrollee using the following steps. It gives you 5 steps that you got to follow to determine the value of that usufruct. Number 1, Determine the equity value of the proportionate share of the property to which the applicant enrollee has separate usufruct rights. Okay, so let's plug some numbers and an example into this. Let's say Millie has the usufruct of a piece of raw land, and that underlying piece of raw land is worth $100,000. And oh, by the way, she went to a lawyer and they just figured, why doesn't Millie donate that land to her 2 children and reserve the usufruct? And they felt like that was getting it out of Millie's name for nursing home purposes. So now Millie's applying for a nursing home. It's perhaps years later, and so they have to go through this process. Number 1, determine the value of the land, $100,000. And let's say Millie is 75 years old. Then it says refer to a certain schedule called Z1300, usufruct and remainder interest tables. There's your schedule right there. Number 3, select the line for the age at the last birthday of the owner of usufruct on the chart. So we're going to pick the 75 age. And it says, number 4, multiply the figure in the usufruct column for the age by the equity value of the proportionate share of the property. So now we have to look at the table, which says if a 75-year-old has the usufruct of property, multiply the value of the property by 0.52149, and when you do that math, it comes to $52,149. Number 5, the result is the usufruct value. So Millie has the usufruct of a piece of land. The land is worth $100,000. Millie's 75. She has this right to use the land for the rest of her lifetime. I don't know how long that will be. And Medicaid is saying the value of Millie's usufruct is $52,149. In reality, it ain't worth that much. Who would want to, and it even says in the Medicaid manual, the owner has the right to sell his or her usufruct interest. But nobody in their right mind is going to want to purchase the usufruct from a 75-year-old whose usufruct will only last for the rest of their lifetime when the underlying property doesn't produce any income or benefit from which a usufructuary would benefit from. So, but nonetheless, under Medicaid, that usufruct interest is worth $52,149. That's going to cause Millie's assets to be well over $2,000. Now what does Millie do? She has to somehow find a buyer for that usufruct interest, sell her usufruct interest, spend the proceeds of the sale down until she has less than $2,000. A real mess on her hands. Okay, so, if you own real estate and you're worried that you might go into a nursing home and you'll be forced to sell that real estate and spend the proceeds on your care, what should you do? Well, just a couple of examples is one, you could just donate the property outright to your children, but a lot of parents don't like doing that. I think the main reason is they don't want to lose control over that property. And if it is income producing, they don't want to lose that income. They don't want to have the family lose the step up in basis. And there's lots of other potential problems if you donate property outright to your children. Now that property is subject to your children's debts or lawsuits or medical issues or spending habits. Perhaps even your children might pass away before you, and perhaps they might get divorced. It might be an issue there. And you just can't change your mind on anything when you donate property outright to your children. So what some people do is they create a very, very particular, follow the rules, family trust, and they donate property to their family trust, and it enables them to retain more elements of control than if they had just donated the property outright. One other side note is if Millie was married and Millie was going into the nursing home, or her husband was going into the nursing home. The point I'm trying to make is if only one of them goes into the nursing home, that married couple under the Community Spouse Resource Allowance rules can have roughly $128,000 and change in countable resources. So perhaps even though they had done this reservation of the usufruct, and even though that Usufruct value is $52,149. They might be okay if one of the spouse goes into the nursing home and one stays at home in the community, because that married couple can have the $128,000 amount. So if the value of that usufruct plus the value of Millie and her spouse's other accountable resources do not exceed that community spouse resource allowance amount, then they may be, okay on that note. So, but that's another particular set of circumstances. Okay, so really important now, especially on this Medicaid stuff. That's not all we do, but it's a part of what we do. Is part of estate planning now is protecting what you have from the nursing home. Really important that you hit this, in fact, smash it. Smash that subscribe button and the notification bell so you don't miss anything. And then a thumbs up would be fantastic. If you have any comments that are, especially I like to read the ones that are maybe a little bit thought out and kind of proofread and grammatically halfway at least correct. Those are awesome, and especially if they're positive and constructive, then everybody can benefit from it. So contributing comments are phenomenal. You can also share, hit the little share arrow, and by either texting or emailing, you can share with other people who might have a similar concern. Tune in tomorrow morning, 10 a.m. Central Time, new video published, educating the public on estate planning. I'm Paul Rabalais. Go and have a great day.